Hello, you Midas Mighty. Harry Litman of Talking Feds here to give you my reaction to the latest developments in the Mar-a-Lago saga, which has had more than its share of twists and turns. So just to review the bidding very briefly, Trump was able to get a district court judge, and not just any district court judge, one who was not burdened by traditional ideas of judicial responsibility and competence, Eileen Cannon, to rule for him basically twice. And she had held that Trump might have some possessory interest in some documents that are marked classified. I say that carefully. The subpoena called for documents marked classified. And any documents that are classified, it's clear. Trump didn't even try to argue otherwise. Trump has no interest in, there's no ability to claim attorney-client executive privilege or anything like that. Instead, he made these kind of bizarre arguments that Judge Cannon adopted, which is, well, the government says they're classified, but how do you know they are? You know, makes your head spin to think about it. That's what it means to be classified. The government, the, authority for doing it marks it classified. And the other thing he said was, maybe, I'm not like raising my right hand or anything, but maybe I declassified them when I was in office, which is something I had a right to do. All right, so Cannon, rather than kicking these arguments immediately to the curb where they belonged, appointed a special counsel and gave him responsibility, Raymond Dearie, a senior judge in Brooklyn, to make these calls. And she said, she credited both of Trump's kind of crazy suppositions and said, since things are contested, I want to have the view of a neutral third party. Of course, they weren't contested in what it means under the law. They had some lines in a legal filing, but nothing in terms of evidence. And that came home today when a real judge showed up, and that was Raymond Dearie, the special master. He held his initial hearing today and before the parties, and he right away came out of the box and said, what's this deal with maybe I declassified, maybe I didn't. Did you or didn't you? Well, we don't want to say, Your Honor, because we want to save that for maybe a defense if Trump's indicted. Well, first, it couldn't be a defense because the possible statutes he's violated don't require classification status as an element, but also, look, he's now in there challenging and saying, I want my documents back. He can't just, as Dearie said, have his cake and eat it too. So Dearie said, I don't see it that way. Here's how I see it. The government's produced some evidence that they're classified, and you've produced nothing. That means that they're classified unless you come in with some kind of declaration or whatever. And that ain't happening because it would be proof that would be put to the test. If the lawyer said it, they could have professional sanctions. If Trump said it, he could be liable for perjury. And it's just pretty clear that this never happened. So Dearie, that didn't say exactly what he was going to do, but what it felt like to me and others is he was going to accept the Department of Justice's submission that these are now classified. And since Trump clearly has no right to any classified documents, those 100, which, by the way, Judge Cannon told him to deal with first, he's going to report to her, he works for her here, that these 100, I think, are good to go. That's what makes sense based on what he said on the bench. And Cannon can say, well, good, now there's been a neutral third party to look at them, so I feel better. Of course, what she said was, since Trump said, maybe I declassified him, that's good enough, and Dearie expressly contradicted that. He said, that's not a dispute. You want to dispute? Let's hear some evidence. So Dearie now has them. He might give the 100 back. In the meantime, the 11th Circuit, Trump has filed his action and papers in front of. The DOJ will have a quick reply. But they will the 11th Circuit, be looking at granting a stay. So the most sort of mischievous and baffling aspects of the Cannon opinion may be in the process of drying up. And what that will leave is sort of hassle and some delays, but not nearly the damage that her true legal, free of legal reasoning opinions have caused. So we will look to see soon what Cannon receives from Dearie. We may not know it, but if they say give back the 100 documents, then we may. We'll look real soon to see what the 11th Circuit does and how quickly they expedite the appeal of Cannon's second ruling, the failure to grant a stay. So more twists and turns in the offing, and it seems at least there are judges on the scene, and that's good news for the Department of Justice and for the cause of justice, because Judge Cannon really delivered a couple opinions that were absolutely bonkers. There you have it, you Midas Mighty, Harry Litman of Talking Feds. Hey, we have our own YouTube channel now. We're excited about it. You can check it out. Just go to YouTube and put in Talking Feds. There will be, no doubt, some twists and turns in the near future on this and other matters, and when they are, expect me back to give you my reaction, and until then, talk to you later.
MeidasTouch is unapologetically pro-democracy, and look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.